There's no option. There is not now an adequate effort to decarbonize either the United States economic system or the atmosphere. We need to do both, and as you know, rapidly. And this is the straightforward path to getting that done.
Hello, everyone, and thank you for joining us at another Climate Emergency Forum. We're always glad to have you here, and we're glad to have our special guest, Dan, back with us. So thank you so much, Dan, for coming back to the forum. The last time you joined us, Dan, you talked with us and shared with us about the Climate Protection and Restoration Initiative and its first two major campaigns. And you'd also mentioned that there had been a recent case before the United States Supreme Court that you're following very closely. And that is the West Virginia versus Environmental Protection Agency. I'm just wondering if I can ask you a couple of questions, and that is if you could briefly review CPR's initiative's first two major campaigns, and then if you could share with us the West Virginia versus EPA case and maybe help us understand what that case is and why it's significant in terms of climate change legislation and the way forward.
Absolutely, Regina. Delighted to be with you again, and Paul and Peter. Well, with respect to your first question, reviewing first two major campaigns that are public from CPR Initiative, they both fall under the rubric that the polluters should pay to clean up their mess. The first has to do with the imposition of a rising fee based on the emissions from coal, oil, and gas in order to jumpstart a substantial decarbonization effort in the United States so that we could at last begin to live up to our commitments, including under international law. And the second is even more far-reaching, but necessary in light of the horrific crisis that we and our children and their progeny confront. And that initiative falls under the Toxic Substances Control Act. And it requires a determination by the administrator of the EPA, where in that determination, EPA must decide whether there is a chemical substance, for example here, CO2 and methane, CH4, that is greenhouse gas emissions, or a chemical mixture, here fossil fuels, that present an unreasonable risk of injury to health or the environment. And in that case, the EPA is required, it's not permissible, it's required to impose a series of various requirements, including prohibiting the continued production, or at least restricting the continued production of those materials, the fossil fuels and their products of combustion, CO2 and methane and the rest of the greenhouse gas emissions. And also to regulate the method of disposal of those mixtures and chemical substances. Well, how do we dispose of the products of combustion of fossil fuels? They are simply admitted into the atmosphere. We continue to treat the atmosphere as an open, free sewer. And in that circumstance, that also should be restricted. And so under this petition, the U.S. government would pursue a wide-ranging, substantial phase-out of fossil fuels and compel industry to remove or to pay to remove the excess atmospheric CO2, the so-called legacy greenhouse gas emissions that are heating our planet, that are raising our sea levels, that are driving recurrent wildfire. In any event, those are our two first initiatives. Now, as to your second question, What was this case, West Virginia versus EPA, all about? It was brought by a number of conservative states, including West Virginia. And that's why it's West Virginia versus EPA. But it's West Virginia et al., West Virginia and others versus EPA. It's conservative states and the coal industry against the Environmental Protection Agency. And in this case, and this is a bit strange, they are challenging a policy enacted by the Obama administration under the Clean Air Act. That was called the Clean Power Plan. And under the Clean Power Plan, by rule, states were required to come up with plans to essentially reduce, moderately, but to reduce average emissions rates from existing power plants. And that would have had the effect of limiting the number of coal-fired power plants that actually could continue to operate in the United States, and would establish, after a period of years, a phase-in period, that the remaining fossil fuel plants, if there are still fossil fuel plants, would need to be gas-fired power plants. So states could do that by offsetting some emissions from coal plants by phasing in more fossil fuel plants, or there could be conversion of coal-fired power plants to gas-fired power plants. Gas-fired power plants are less emissions intensive than coal-fired power plants on average. That was challenged in court over several years. It was making its way, and the Supreme Court actually signaled that it was likely to hear this case. But then something happened. That is to say, the Obama term ended and Trump came into power. Trump administration immediately withdrew the Clean Power Plan, and then after a series of months, it put in place its own much more industry-friendly plan. And so you would think the case should have been moot. In fact, I think the case should have been deemed moot. But lo and behold, the conservative states continued to press this and succeeded in getting the Supreme Court to grant it a hearing. And that's what's ominous about this, that in a case that the Supreme Court should have just denied as moot, the Supreme Court said, no, we will hear it. They didn't say exactly why. So at the end of February, February 28, the case was heard by the Supreme Court. And a number of people have been watching it closely because of some of the wider implications, not only of the court taking it, but of some of the arguments that were employed by those conservative states and industry.
So Dan, what is specifically at issue there? And if you can, could you tell us what some of those wider ranging implications are?
Yes, certainly. So specifically, what's at issue is the EPA's interpretation under the Obama administration of Section 111D of the Clean Air Act. In the view of the Obama administration, that means that a state can establish the emissions rate on average for that every source taken into account in a state needs to meet. So you take the average of all the sources, and that system of power plants in the state must have an overall average emissions rate under that standard that is established. So fairly straightforward, no more math is required here than averaging. But the conservative states say, no, this needs to be a plant by plant. So inside the boundary line of every plant, standard of performance tailored to it, so that you cannot require, for example, coal-fired power plants to have to meet on average an emissions rate that is better than coal-fired power plants can actually meet. And you can't look at beyond the fence line issues. And so we take as given our existing power plants, and you can't impose requirements on them that is more than is reasonable for a plant in their category to meet. This has significant implications because in this way, then, you could not really force a retirement of the most emissions intensive plants in any particular state, even over time. And the question is, was EPA's interpretation reasonably allowable? And so that's the nub of the legal issue. But, And this goes to your second question, Regina. The states further advanced something that is called the Major Questions Doctrine. And they said that allowing EPA the discretion to interpret the statute, the law, in the way that they did implicates major questions. Well, what are those? They said major questions arise where an agency is interpreting a law in such a way that it will markedly alter the status quo, here requiring major industrial change. And they said it's unreasonable for EPA to all of a sudden find in the law an authority that allows it to compel wide-ranging change in the power sector. Now, this is quite the doctrine as they would interpret it, because it would mean then, suppose, which is true, that we do need major industrial change in order to confront the climate crisis. I mean, I think the science is quite clear on this. We need a major change in the way we produce power in the United States, in Canada, in Russia, everywhere in the world. We need to phase out the continued reliance on fossil fuels to generate power. That is elementary. It's clear from all the IPCC reports. It'll be made clear again in the forthcoming report of the IPCC in April of 2022. So what that means essentially, if this doctrine is employed as the conservative states would urge, is that EPA could only issue rules that tinkered at the margins and did not affect the broad change necessary to meet the agency's mandate. Well, what is that mandate? That mandate is to protect public health and the environment. And if it has the authority to compel what is necessary, then, at least in my view, it needs to utilize that authority, even if it is so-called technology forcing, even if it requires major changes in the way we do business in a major sector. That's been the case with respect, for example, to its authority to institute emissions control regulations in the auto and light truck area and the transportation. And I think that's true also with respect to the power sector. But in any event, that is what is specifically at issue if the Supreme Court takes up the invitation to vastly expand and stringently utilize this so-called major questions doctrine. And by the way, it implicates not only environmental rulemaking in the United States, but food safety, transportation safety, the whole 9 yards, that really the business of government in protecting the people requires often an interpretation of statutes that are not necessarily perfectly clear on their face, but require a bit of interpretation in light of the fundamental mandates and mission of one or other specific federal agency.
So what you're describing not only spells a great danger in terms of progress, in terms of climate change, but the far-ranging implications.
Right, and to be specific here, the major questions doctrine was recently employed by the Supreme Court to strike down one of the federal government's wide-ranging COVID-19 requirements for large employers. Even though the imposition of a mandate was widely regarded as important at one time, a number of months ago, to combat that crisis, because volunteerism wasn't successfully working. Nonetheless, the Supreme Court stepped in under the rubric of the major questions doctrine. So this is not theoretical merely. This is one of these doctrines that the Supreme Court has devised of its own accord, at the urging, of course, of one or another attorney for one or another interest, to limit the ability of government to undertake action in defense of broad public interests and rights.
Well, I mean, I definitely see that public interests and rights are certainly secondary to monetary acquisition by the major industries of our country and the world. Of course, that said with ultimate sarcasm.
Well, I mean, that's right. But I mean, the courts in the United States, as elsewhere, the third branch of government, are supposed to be a bulwark to protect individual rights, to protect the rights of the public, where there's inadequate representation for those broader interests that may be diffuse, may be politically less organized, including in the environmental arena, including here with respect to the climate crisis. So this is quite a concern, this sharp right drift of the Supreme Court, especially in recent years. Is it able to continue to honor what many people believe to be its fundamental mandate, to interpret the Constitution and the laws under the Constitution in such a way as to protect those individual rights and the fundamental interests of the people?
I know that you have a lot of thoughts regarding a lot of what we've discussed, and I know that you're certainly interested in food and food safety and food equity, Peter, but I'm wondering if this discussion has brought up some other thoughts to your mind.
One of the questions I'd like to ask is that Dan has his group and concerned scientists, and together they're pursuing this initiative under how Dan's explained the Clean Air Act and how it's supposed to operate, and the interpretation of the Clean Air Act and the implications. I want to ask how much, if at all, can concerned citizens give evidence, and how much, if at all, can scientists provide evidence that might help this thing along, because it sounds like, because of the obstruction which has been on for decades by the Republican Party, that this is maybe not going to anywhere fast, and it may even leave us worse off.
Well, you went straight to the $64 trillion question, as you often do. There is a procedure that we are pursuing under the Toxic Substances Control Act for our far-reaching petition to phase out fossil fuel emissions and to compel removal of excess atmospheric CO2 and the other greenhouse gases. And that procedure will be triggered once we file this petition. And then EPA will have 90 days to respond. If they don't respond, we're going to sue them because the law is clear. And they can respond in several different ways, but one of the ways is that they can issue a strong rule. Well, on what basis would they issue a strong rule? And this goes to your point, they'd issue that strong rule on the basis of the evidence and the logic in our petition, which we file, but also on the basis of comments that the public can submit to EPA within that 90-day period. And so this is one of our challenges. We need to mount a campaign to ensure not just that there are, rote postcards saying the same thing, we support the CPR initiative petition. I mean, that would be fine, but it's not of that much use. But we need to ensure that there's a number of people, and it's not just scientists, Peter, it's informed citizens, write to EPA saying that we need this because the United States needs a strong legal foundation for a wide-ranging decarbonization effort. Only then can we show that we are exercising leadership on the world stage, as is necessary if we're going to resolve the climate crisis. More than just words, we need a program of decarbonization in the United States that is realistic and is based on a strong legal foundation. And of course, people can say a lot more than that. EPA needs to take into account all of the comments. Of course, the fossil fuel industry can comment as well and do everything that the fossil fuel industry likes to do, including saying things in the public arena, and we may need to respond. We may need to prosecute this case in the court of public opinion as well as in the actual courts. And then after that period, EPA should make a decision. Now, if the decision is adverse to us, that is to say, if they deny that the law provides the necessary predicate for a rule, or if they come out with a very weak rule, then we have 60 days to go to court. And we can go to court and try to overturn that. And the role of informed scientists in that case may be important, because we would then present the case not to EPA, which is what we'll be doing soon and over that 90-day period, but to the court. And our challenge will be to say that their adverse decision or their weak rule was either contrary to law or arbitrary and capricious. Now, on the other hand, EPA, and I may have said this last time, could come out with a strong rule. And as sure as the sun will rise tomorrow, the fossil fuel industry then, at least sections of it, will challenge. And then we would intervene in a legal case on the side of EPA, and scientists and informed citizens and others can materially help. First, some of them might be so expert that we would use them as expert witnesses, providing expert testimony. But secondly, everyone can help, because we need to now, in this next 5-month period, develop a something of a war chest, so that we can have the full legal team that we need to respond to that complex litigation. I'll be part of that team, but I could use a bit of help. And in addition, we need to utilize the opportunity of such litigation to inform the public more broadly. Why? Well, because sometimes you lose. We might lose a battle. But if we did, then we're going to Congress to say, look, here EPA, under a clear statute, tried to do the right thing, or not, and the courts found that it could not, and therefore we need to change the law. So either way, we are going to utilize this effort to either enforce existing law, which is adequate, or if it's found to be inadequate, to change the law through action in Congress. And again, action in Congress is the result, in part at least, of pressure from informed citizens. So in these several ways then, helping us make the case, helping us to the agency, helping us make the case to the public at large, helping us make the case to the courts, and then, if necessary, helping us make the case to Congress, we will be pressing this forward. There's no option. There is not now an adequate effort to decarbonize either the United States economic system or the atmosphere. We need to do both, and as you know, rapidly. And this is the straightforward path to getting that done.
Yeah, we definitely need to do that. We definitely absolutely need to do that rapidly. Thank you so much. And I really appreciate your saying that people can help. And I'd like to be able to put that link down there, or at least in the description, the address to the EPA, where people can reach out and do just what you said, to express their concern and how this is so very important. So shout out to those of you who are watching. Please look in the description. And if you are so moved, your voice does matter. So please help with this effort.
The organization is Climate Protection and Restoration Initiative, as you talked about. But the website URL is very easy. It's CPR, because Climate Protection and Restoration. So cprclimate.org. And we have a page on this particular campaign where people can get information about the petition, get information on how to make a donation to ensure that we can get this work done effectively. And once the docket is open, we will have information as to how people can most efficiently file their comments. The ability to file comments will be by mail or fax or by email. So EPA thankfully makes this relatively easy. And in turn, we will make it as easy as possible for persons who will visit our website and in the attempt to help us get this done.
That's great, Dan. And you've made it so easy that all of you out there watching, no reason not to do it. Go to that website, cprclimate.org, and do your bit. I know you can, and I know it matters to you. We appreciate that. Paul, I know you've been sitting there just chomping at the bit, so I'm wondering if you may have any questions for Dan.
Yeah, well, I think it's becoming clearer to more and more people around the planet that we're really in a climate emergency crisis situation. And these extreme weather events are disrupting more and more of society. I think foremost, what is coming is a very likely food shortage, because food growing regions are being hit by extreme weather events from a changing climate, and supply lines have been severely disrupted in the last couple of years of the pandemic, et cetera, et cetera. So all these things seem to be coming to a head. Do we need something beyond the EPA? Do we need a climate change emergency group, an agency, administration with power to ram things through and to avoid a lot of these skirmishes between states and the federal government, et cetera?
Well, I'm really glad you raised this. And you asked two questions. You make the point that we're in a crisis. And then you ask how best that can be responded to, for example, by the federal government. By the way, the United States has a federalist system of government, and federal government action is not the only avenue for significant action. There can be significant action at the state level and even at the local level. So do we need emergency action? And then if we do we need emergency action by an agency or an arm of the federal government other than the EPA? I want to answer that second question first. And this is actually in our petition too, but it was a little more complicated, and I don't usually lead with that. But in the event that there's not merely an unreasonable risk of injury to health and the environment, but that's an imminent unreasonable risk of widespread injury to health and the environment, then in that circumstance, EPA can exercise, it's not termed this in the law, but essentially emergency powers. Now, we can't do this willy-nilly. It can't just go out and seize coal-fired power plants, but it can go to court directly to seize these chemical substances and mixtures under not Section 6 of the Toxic Substances Control Act, but Section 7. This is in our petition, as I say. This is not a section of the law that we can invoke directly in a citizen's petition under the Toxic Substances Control Act. Nonetheless, we attempt to invoke this section. How? Well, because the United States Constitution says that citizens may petition for a redress of grievances. So our petition attempts to exercise citizens' rights under Section 21 of the Toxic Substances Control Act that allows citizens' petitions to enforce Section 6. But under the Constitution, we can at least request that EPA exercise its authority to declare these substances to be imminent hazards of widespread injury to health and the environment. In that circumstance, you don't need to undertake rulemaking. EPA can go directly to a district court and say, Judge, we are in an emergency. These substances, perhaps they didn't 60 years ago, but these substances and mixtures now present an imminent hazard of widespread injury to health and the environment. So severe that we can't wait for 6 months or a year or so after litigation would conclude. We need you to take action right now. to authorize us to take action right now to address this problem. So I mentioned this because we actually don't have to go outside EPA. We don't need to invoke powers akin to the war powers or anything like that. It is built in to this fundamental statute in environmental law in the United States that where there is an imminent hazard, the appropriate agency can go and tell it to the judge, and the judge then can authorize such emergency action as may be necessary.
So I'm wondering, Dan, how do you think, if you can look into your crystal ball, how do you think West Virginia versus EPA will turn out, and when will we hear about it?
Well, let me first say that I think that our petition, because it's based on language, as I indicated before, in the Toxic Substances Control Act and not the Clean Air Act, where that language that we rely on is crystal clear. Even if the provisions at issue in the West Virginia case are not as clear, even the worst decision by the Supreme Court would not undermine our efforts. I first want to say that I think that our legal arguments will be stronger and could survive even the worst type of decision here by the Supreme Court. But that said, I still think that the Clean Power Plan, as it was written by the Obama administration, should survive, and the Supreme Court should reject the arguments of West Virginia, Texas, and the oil industry. But it's hard, really. You asked me how I think it will turn out. It's really hard for me to predict how that will turn out. And if they go against, I think first that they should just throw the case out of court under basic conservative principles, that the court, any court, should not decide a matter where there's no live case or controversy. And the Trump administration rescinded the Clean Power Plan. The Biden administration says that it's not going to put it back. There's no Clean Power Plan to rule on, and so they should just toss the case out of court. But if they don't do that and decide to decide the case before them, then I think they should decide it on narrow legal construction grounds. What is the proper reading of the specific provision at issue there, Section 111D of the Clean Air Act? And then if they decide to go, broad and utilize this doctrine, which we've talked about, the so-called major questions doctrine as a meat cleaver, I think all bets are off. In terms of when, I don't know. They don't necessarily have to issue their decisions in order of argument. All I can say is sometime before October, but it actually could be quite a bit sooner. I can commit to come back to you and discuss the actual decision whenever it's done, but I can't right now tell you exactly when it will be issued.
Well, we're on tenterhooks now, Dan. Oh my gosh. It's let's just hope that it comes soon so that we don't have to wait. And let's hope, as you say, let's hope that they go narrow and not broad. But whatever the case may be, we would absolutely love to have you back. Of course we would. Not only do I want to thank you for Peter, for Paul, for everyone at the Climate Emergency Forum, but on behalf of our guests, listen, Dan brought up a lot. He brought up a lot of different things. So please put your comments or your questions in the comments below. Heck, we may even have Dan come back to answer some of your questions that you write for us down there. So please do. Let's continue the conversation. Please hit that like and subscribe button and share this video, and we'll see you at the next time at Climate Emergency Forum.